All right, guys, I am here today with a super requested topic, all things contracts and how to be legally legit in our businesses. So you guys have mentioned so many times feeling like, which I can relate to this, that the legal side of our businesses can be really scary. And so my hope is that this episode will ease some of those fears and allow you to get clarity on your biggest questions, specifically around using contracts. So I'm chatting today with Kailey Jacomet from Contractista. And Kailey's a lawyer for small businesses. She's a wife, she's a mother, and she's a baby on the way actually during this interview. And in her shop, she sells contract templates. So she was the perfect person to quiz about all things contracts. And I really love the questions I asked her. So to kind of give you a sneak peek into a little bit about what you'll hear us discuss, we talk about when the right time is to start using contracts in your businesses. We talk about how contracts fit into providing a great client experience. We talk about what it means to do like an attorney drafted contract or just writing your own contract and kind of how to figure all that out. Like, can you just pull something off the internet? Can you write it yourself? All of that kind of stuff. We talk about must-have clauses to include in your contracts. And as a website designer, I share some must-have things for me that I think you guys will really love hearing that are like things I've added into my contracts over the years that really help me. We also talk about copying in the online space and how to legally protect yourself and deal with something you created being copied or stolen. We also talk about copywriting our websites and so much more. That's just a little sneak peek into it, but it's a really great conversation. So without further ado, I'm going to play this interview with Kailey. And yeah, I hope this brings you guys major clarity around your own contracts and the legal side of your business. Hey guys, it's Elizabeth McCravey, and you're listening to the Breakthrough Brand Podcast. Each week, I'll bring you workshop-style trainings that teach you how to stand out online, design success from the inside out, and create a breakthrough business. It's time to turn viewers into raving fans and design the business and life of your dreams. I'm so excited you're here. Okay, guys, welcome back to another episode of the Breakthrough Brand Podcast. I'm excited about this one because this topic of contracts has been such a requested one by all of you, and I have an actual expert, an attorney on all the things here with me. So welcome, Kailey. I'm so excited for this.
Hi, Elizabeth. Thank you so much for having me today.
Yeah, it's going to be fun. So, okay, to start, for those listening who don't know you, can you share a bit of your story, like who you help, how you got into, I think it's interesting, how you got into like the online business side from being a traditional attorney beforehand. So all of that.
Yeah, I would love to. So I'm a business attorney. I have a trademark practice called Brand Law Boutique, where I help businesses protect their brand through trademark registration. And then I have another business, Contractista, where I provide contract templates that are attorney drafted that you can just download and customize and use in your business. So my journey into entrepreneurship was, I never actually thought I would be an entrepreneur. I was a trial attorney, so I was in the courtroom all the time. And to be honest, I really didn't enjoy being in the courtroom, but that's where I was finding myself. And then when I got pregnant with my daughter, I knew that I wanted to be with her, at least when she was a baby, pretty full time. And that something was going to have to give. Either my vision of motherhood was going to have to shift, or I was going to have to change my career. And honestly, so now I have a virtual practice. I work mainly with online businesses, and I work from home part-time. But at the time, I didn't see anybody doing that. I didn't have any examples of that. I saw the field that I was in as being pretty inflexible. So I thought I was just going to have to leave the law and find something else to do. But eventually I did meet a trademark attorney in the city we live in, and he had more of a traditional practice, but he had a home office. And everything about trademark law lends itself to a virtual business. So it's like e-filings and things like that. And so the light bulb started going off. And at the same time, I was kind of going down this path of learning about online businesses. And I really enjoyed watching other people build brands. and build their business. And so I kind of tried to learn from other industries and sort of spice up what I was doing in my legal practice to make it not so, sterile. Like I don't have a brick and mortar law firm where people are like coming to my office on Main Street. It's just me and a laptop and wherever I go, and getting into social media for marketing and things like that. So that's my story. And it's worked really well because we're expecting baby number 2 now, and I don't need to worry about what I'm going to do when he comes.
Yeah, I love that. And I feel like your story is such a good example of like, you can create whatever you want when it comes to your business of like, you have this degree and interest in the law, and it doesn't have to look like the way everyone told you it did. So, and I want everyone, we'll link to in the show notes, but definitely to check out your contract shop, which everything we're talking about is going to relate so heavily to. But something that's fun about it, I actually have your website pulled up like as we're talking, but you use pink and it feels like feminine and inviting and not scary like so many of us probably feel thinking about all the legal side of our business. I know that's why like this has been such a requested topic, is because people are like scared they're doing it wrong. And I personally just appreciate it when brands doing something that is super important like that and is legal, but feels like more inviting and welcoming and all that. So I like that about your website and brand. Yeah.
Well, thank
Okay.
you.
Yeah. So, okay, let's just dive right into all the contract stuff. So, I have a lot of questions that people who listen to the show have sent in, and also some that like I just think of with contracts myself. So, to kind of start, we're talking about contracts as service businesses, meaning like the contract mostly that a client and us will go into together to do a project. So thinking about that, like when do we need to start using contracts? Like when's the right time? Like the first project after we're more experienced a little, like when's the right timing?
Yeah, so definitely you want to have a contract for your very first client. Sometimes I hear people say, that they want to make a certain amount of money in their business first before they start dealing with contracts. Or even, and we don't need to get into this topic, but before they actually register their business, they want to make a certain amount of money. And really, a contract protects you from liability. It does a lot of things that we'll get into, but one of its main functions is to protect you from liability. And you are exposed to liability when you potentially make a mistake. Now, none of us think that we're going to make a mistake, but we're all human. And when are you more likely to make a mistake? When you're just starting out or when you've been doing this for years? So really, it's kind of the opposite. I mean, you want to protect yourself from the very beginning, not wait until you have several clients under your belt, because there are certain clauses in your contract that without those present, you are going to potentially be exposed to more liability than if you had a properly drafted contract in place.
Yeah. Well, and like something too, I mean, I know a lot of people listening are already past that first client and maybe they didn't use a contract. I know for me, my first few clients, I did not have a contract in all honesty. And some of them, it was like a quick, like wake up call of like, oh my gosh, I need a contract. So it's better to go ahead and start using contracts before you have that sad wake up moment. Because for me, it was I had a client ghost me on payments, and it was like we
Oh,
actually had no agreement about anything, and they had paid like I think it was a 3 or 4 installment plan, paid like the first 2, and then I never heard from them. And so it's like I didn't really have much like weight to go in there. So like doing the contract thing, before you like so desperately need it and have that bad situation is important.
right. Because once you get into that situation, it's generally too late. And there's
Yeah.
so many different ways that a contract protects you, in terms of limiting your liability, but also making sure that you get paid, the terms of that payment. And it's also a roadmap for your relationship with your client.
Yeah. Yeah. Let's talk about that one of like when we think about, because I mean, everyone wants to make a great client experience. I know I talk about that. And as like a designer and, photographers, coaches, everyone listening, that's such an important thing to everyone. How would you say the contracts relate to a client experience?
Yeah, in two ways. First, like I mentioned, they are a roadmap to your relationship.
Yeah.
So, sometimes people think of legal disputes as someone is out to get you, or they're just a really terrible client. But it can also come up that you'll have a client problem just because of a misunderstanding. To be unclear is to be unkind. And so your
Mhm.
contract sets forth, here are my expectations, here are your expectations. You and I are agreeing that we're on the same page. And if this problem comes up, we've already decided that this is how we're going to handle it. Or if this happens, we have already decided that this is how we're going to handle it. And so I imagine that you probably have both men and women listening, but a lot of your listeners are probably women. And
Yeah.
so, not to stereotype, but sometimes we might not want to confront someone like too aggressively if there's a problem. And when you have a contract, it's just so much easier to fall back on that. It's a good conversation starter. It's a good way to direct the conversation when something comes up, bringing up, okay, this is going on. And as we agreed in our contract, this is how we're going to handle it. So it takes the pressure off of you when dealing with those tough client situations.
Yes. I've said that before to people of like blame it on the contract, which doesn't mean being like,
Yes.
well, in my contract in clause 5, I say this, but it more so being like, hey, we agreed to this. And for reference, like, here's the answer to your question in this document. It does make it so much easier. It's like the contract says that language. And I love what you said, to
Yeah.
be unclear is to be unkind. And that's so true about so much of like, and many people listening, I can't remember the episode numbers. I'll link to them in the show notes, but I have 2 episodes on dealing with difficult clients and preventing difficult client situations. And on the preventing episode, I talk about contracts, because when
Mm.
everyone's on the same page, there's that clarity you're talking about of like, to be unclear is to be unkind. And then people are naturally, things will fall into place more there. So I love that.
Yeah, absolutely. Another thing about the client experience as it relates to contracts is making sure that the language is balanced and fair.
Mhm.
So when you present a contract to a client and it's your contract that you're giving to them to sign, it is going to be kind of slanted in your favor, and it should be. And that's just the way that it works, right? When you've drafted it or someone has drafted it for you. But you don't want to give your client a contract that is like very, very one-sided, that doesn't seem to protect them at all, that doesn't hold you to any certain obligations. And of course it would, in terms of the scope of services, but you want it to be balanced and professional. So in all of our templates, I mean, they are, they're slanted to the business owner in certain ways. For example, the choice of law. So if, let's say, you are in Tennessee and I'm in Missouri, and so it's your contract, and so the governing law is going to be Tennessee law. Or you're going to say, we agree that if we do get into a dispute, it's going to be handled in the state of Tennessee. So those sort of things are definitely slanted toward the person providing the contract. And then other clauses like limiting your liability. So that's a really important type of clause to have, where you're saying, even if I mess up, you and I are agreeing up front that this is the maximum amount of money that I'm going to be responsible for. So even if my actions create this like domino effect, like, just you couldn't have predicted that this would happen and
Yeah.
this would happen and that would lead to this, that I'm only going to be responsible for a certain amount of money, even in that worst case scenario. And usually that language isn't reciprocal. Usually it's just for you, the business owner, but the rest of the agreement should be balanced and reciprocal. It should set forth, their expectations, your responsibilities, and things like that. So that really adds to the client experience, because they know they can trust you, and it's just a professional agreement.
Yeah, I love that. And can you think of any examples of ways, like clauses specifically, that are holding us accountable instead of the opposite, that we can like make sure we're having?
Right. Yeah. So anything that sets out your responsibilities besides just the services you're providing. So let's say
Yeah.
you're designing a website for someone, for example, and you're going to, deliver this in a certain timeline for this price. Those are like the basics, right? But then beyond that, you can include things like that you have an obligation to communicate with your client, that if anything is going to be late, that you're going to be, communicating with them openly. And let's see, things like non-disclosure, for example, like you're not going to tell other people about this new business that they're making, or the details of their business, or the private information that you gather from them. You're going to keep that confidential, things like that.
Yeah, I have that. I have some of those in my contract, specifically that non-disclosure one, I think is so important because in all of these types of industries, everyone listening, but like for me, I often will get everyone's passwords that I work with. I sometimes get into people's like Dubsado account where I'm seeing their financial information because they're giving me the login to add forms. And so saying like, I'm not going to be snooping in all of that or like sharing, telling all the details of it. So yeah, those are great examples of that. And I totally am with you on it. That's a smart, like that's something we need to think about, that it is to protect us, but also them. And so it shouldn't just be like me of what I get from it. So I love that. Okay. Another question for you. When it comes to like creating the contract, sometimes people write their own contract. Sometimes people find a lot of like, here, I like this thing I found on this free website, and people buy, templates like what you sell. People get attorney, like actually hire someone to write their custom contract. How do you know what to do to make your contract?
So any contract should definitely be drafted by an attorney. Ideally, the best situation is that you hire an attorney to draft a custom agreement for you. And then the second best option is to have an attorney drafted template that specific to your niche. And so that's very important too. You don't want to just, even if it's an attorney drafted contract, if it's not for your industry or the types of services you're providing, then it may be lacking in certain clauses that you really need. So for example, my coaching contract template is very different from the designer contract. They require different things. They're providing totally different services. So an independent contractor agreement is kind of a catch-all. So let's say that you were a consultant and maybe you can't find a template that really suits you specifically what you're doing, then an independent contractor agreement is kind of going to be your bread and butter sort of agreement. But then there are certain things that if you're coaching someone, you really want to add in, like disclaimers. And then if you're a graphic designer or a website designer, there are other types of clauses that you want to add in to address, certain design elements. And then copyright is very specific. I'll get into that later, but you actually, as the creator of those designs, you own the copyright, not the person that is commissioning you to do that work. So you actually have to transfer the copyright to them, and you do that in your contract. A coach doesn't need to worry about that. So it's important to have a contract that is specifically for your niche and attorney drafted. If someone can do it custom for you, of course, that's the best option. Now, the reason you shouldn't just grab something off the internet if you don't know who it's written by is writing a contract is a lot like writing code for a website. So it's not just words that are strung together that, oh, this sounds nice, or this kind of communicates a point. It actually has an operative function. So just like when you're writing code and you add in a word or, a letter or something like that, and it actually changes the function of what that code is doing. So, you hit like refresh and publish, and you can see that it changed the website. It had an operative function, and a contract is the same way. It's not just words that sound nice together, but even one word can change the legal operative function of the outcome of the situation. So it's really important that it's drafted by someone who is trained in doing that and is aware of those nuances and the implications to your business.
Yeah, that's so helpful. And then like kind of a question with that, say someone did get a template or even hire an attorney to custom draft one, and then they have like additions they add on themselves later. Is that also like a dangerous idea, or is that okay once like the beginning of it was set?
Well, I think it matters what it is. So if you're adding in clauses that are more like, I'll say legalese clauses, like let's say, so a non-solicitation clause, means that if you're working with someone or if you're working in someone's business, you're not going to be going through their client list and like taking their client information and then going out and like contacting them later on for your own business. And the way that would be drafted would be kind of going back to the coding example, very specific words. It would probably involve what you would think of as legalese, and you want to make sure that that's drafted properly. And that's not something that I would write if you don't have a background and just stick into your contract. And there are, endless more examples like that. But let's say that you were adding something to your package. And so you're adding like more deliverable timelines, or maybe if you are on retainer or something like that, and your client has some expectations of what days you're going to be available, or you're saying like, I'm not going to be available the month of December or something like that. I think that's stuff that you can add in yourself that would typically be under the scope of services. So those type of details that really relate to the operation of your business is fine to add in, but I wouldn't play around with more legally operative clauses.
Yeah, that makes a lot of sense. Yeah, because that's the thing I've thought about is like you might buy a template, but then need it to grow with you in different areas. So yes, that makes a lot of sense. So going with not a free hodgepodge contract. I love that. Another question for you, like what, I guess clauses is the right word. This is not my expertise, but what clauses should service businesses particularly, like what are some things where you're like, that is a must have for every contract that people need to make sure they don't miss? Interrupting this episode with a suggestion for the small business owners listening. Ever wonder what you should do for healthcare when you and your spouse are both self-employed so there's no work-provided health insurance to participate in? Well, when my husband Adam joined me in the entrepreneurial job space over 4 years ago, we joined Christian Healthcare Ministries instead of getting traditional health insurance. And it was the best decision for us, especially in these years of growing and raising a family while also running multiple businesses. CHM is a health cost-sharing ministry and is a faith-based alternative to health insurance. We did tons of research before choosing CHM, and if you know me and Adam, you know we are all about doing the math when making big or small financial decisions. And even though it's not insurance, CHM shares 100% of eligible medical bills, which is more than the typical 70 or 80% of medical bills paid for by insurance companies. All sharing is determined by the CHM guidelines, which you can check out before and after joining. And for the mamas and mamas to be listening, you truly cannot find a better healthcare option for maternity care. I had a vaginal delivery and a C-section and birth center care and hospital care between my 2 pregnancies and births, and it was all 100% shared for. And outside of birth, we've had our share of emergency room visits and procedures as a family, and those costs were all shared by members at Christian Healthcare Ministries, leaving us only paying our monthly contribution. CHM is less expensive month to month than insurance, and because there's no network, you can choose your care with whichever providers best fit your family. I seriously just cannot recommend Christian Healthcare Ministries enough. You've got to check them out. Go to elizabethmccravey.com/CHM for more information. Also putting that link in the show notes, elizabethmccravey.com/CHM. Now back to the episode.
Yeah, there are several. And so I don't want to leave any out. And again, it will depend on your industry, but just in general, things that are going to show up in any type of service provider contract, your scope of services. And so that could be labeled different things. It could be labeled package details or scope of services. And there you're including all of your deliverables and the timeline ideally too. Of course, terms of payment, that's really important. And then within that, not just how much you're going to be paid, but the timeline of payment as well. And then if you're going to have any type of penalty for late payment, you want to include that as well. Limitation of liability, that's really important. And that gets back to preventing against the domino effect. So I'm trying to think of an analogy, but let's say that you make a website for someone, and I think you and I maybe talked about this example before, and you say you're not responsible for making sure their hosting subscription, and I'm not very up to date on those terms, but is up to date. So let's say their GoDaddy expires or whatever, and you weren't responsible for that. Or let's pretend you were, actually, for this example. Let's pretend you were responsible for that. So you did not renew that for them. And then their website was down, and then they lost, and it was right before a big launch. And historically, let's say they've done like 10-figure launches, and that's what they were expecting.
Mm-hmm.
The website was down completely. And so they didn't make any money during that launch. There were no sales for that period of time. I don't know if this is like a realistic example, but I'm just describing something that sounds
helpful.
Horrible. And so in your limitation of liability clause, that would be like a hypothetical example of this domino effect that you couldn't predict. And so let's say in the limitation of liability clause, you said that even if you make a mistake, the maximum amount of money that you're going to owe them is going to be equivalent to 3 months of your retainer, or it's going to be equivalent to the full package price. Now, that doesn't mean that any mistake you make that you're going to owe them the full package price, because they still have to prove that their damages equaled that amount. But what it means is if they lose $20,000 in a launch because of this little mistake that you made, that you're not going to be responsible to them for the 20,000. But hypothetically, if they could show that, but for your mistake, they wouldn't have lost this money, and you didn't have that kind of language in your contract protecting you, it's possible that they could sue you for the $20,000.
Yeah, that is a crazy example, but totally like possible. And to kind of tell people what we had talked about of the actual real example from my business. I've talked with this client once. I had a really bad client once that was really just a challenging situation. And I did have a contract, which was perfect for this situation, but a year or two after working with them, sent me a text message threatening to sue me because their website went down. And the reason was because they did not pay for GoDaddy when it expired. And, GoDaddy continues to email you, hey, your domain's about to expire, and you have to renew it yourself. And they didn't. And were trying to say it was my fault. And I actually helped them get it back up. But that's something I had in my contract of like hosting, domain fees, all of it is your responsibility, not mine. It's obviously not worded like that, but like that in the contract. Because that's something some, I guess, crazy clients could try to sue over. And that's a question too, I guess, if someone were to try to sue over something like that and it wasn't in the contract, like, could they actually get anything? Could that actually work? Because that sounds so ridiculous, that situation especially.
Yeah, I think it really matters. It matters the wording of the contract, the lack of that being included in the contract. If that wasn't your responsibility, the law wouldn't imply that it was. It's not. So if that wasn't in the contract as one of your obligations to them, it's so fact specific, but I would say that they were probably barking up the wrong tree. It was their own fault. But yeah, that's definitely a scary situation. I think that's also a great example of, you asked, as you have a contract and you think of things that you want to add to it as your business grows. So let's say that you were a VA, and maybe the types of projects that you take on vary. And so maybe something comes up where you're helping them set up a digital course or something like that. So a clause like you just mentioned, I'm not responsible for keeping up with your Kajabi fees or renewals, something like that that's relevant to the situation. That's something that you can add in to your contract. I think that would fall more under the concept of the operations of your business legally. So definitely as things change and as you think of things, add that sort of language to your contract.
Yeah, I love that example with Kajabi, because that is one where it's like, every client's different. So there's going to be maybe different softwares worth mentioning. Also, when you were talking about scope of project being something to mention, like kind of going back to what I just said a minute ago about like, hey, GoDaddy fees are your own responsibility. Something I do is I actually will list out things that some people might think are a piece of the project, but aren't. and saying these are not included. So like one thing I list is photography is not included. The purchase of stock images is not included. You know, if I was making
Yeah.
someone's website and they're like, hey, I actually need photos for this. Like, yeah, I'm not paying for your photographer. So kind of saying that because some people might, just to make sure like everything's as clear as possible. Also for designers, like, are you buying the fonts for your client or are they responsible for purchasing it? Some of that kind of stuff that comes up during the
Yeah,
project.
absolutely. That's very important because that's also going to vary from client to client, right?
Mm-hmm.
So in my own business, similarly, for trademark registration, my legal fees, and then there are government filing fees. So when you file a
Mm-hmm.
trademark, you pay the government a certain fee, and that fee varies depending on the type of good or services you're offering. So if you're doing a bunch of different things, then you're going to have multiple fees. So those are separate from my legal fees, and I also make that clear in my contract because, like you said, you might be using different fonts, different stock photos. Those types of fees are going to vary from client to client. So it's also not practical for your own business model to really include those fees if you wanted to, because they're just going to vary for each person.
Yeah, great example. Yeah, okay, so let's talk about you already kind of mentioned this a minute ago, but copyright ownership for created work. So just I don't even know how to ask the right question, but you just gotta tell us about that.
Yeah, sure. Yeah. So copyright is the rights that you have over an original work of art. So that could be anything from like a poem to a blog article to a photograph that you take, to graphics that you make, to the look of a website, the website that you create, to even if you're writing code, that you actually have copyright to the code that you write. Any original work of art. So you can't copyright facts. Facts are not copyrightable, but even the expression of those facts can be copyrighted. So like if you have a nonfiction book, you can't stop someone else from, writing about those same facts, but
Mhm.
the way that you put the words together, the way that you put your paragraphs together, you're going to have copyright ownership over that. And so copyrights can be registered with the US government, with the US Copyright Office, but you also have automatic common law rights to any work that you create automatically. And I would say, because all of us are creating so many things every day, whether you're aware of it or not, that are potentially copyrightable. The things that you actually want to register are more like, books, things that you really publish, and, maybe a photograph if you were making money off of it,
Yeah.
things like that. But otherwise, you do have automatic common law rights to the original work of art. And what a lot of people incorrectly believe, and it's kind of common sense to think this way, is just the law is not common sense all the time. But when you are commissioned to create something for a client, so they hire you, you have a contract, they're going to pay you to create a website, or they're going to pay you to ghostwrite a book, you might assume that since they're paying you to do it, that they own the copyright to it and they're just hiring you to do the work. But the law assumes that the copyright belongs to the author or the creator. And there are a couple exceptions to this, but mostly in the freelance world, the exceptions don't apply. So if you are an employee, so you're a W-2 employee, like you're on payroll, and what you're doing is within the scope of your employment. So like you're a W-2 payrolled writer that is on payroll for this company, writing articles for them, then the copyright is going to be owned by the business who is your employer automatically. But if you're an independent contractor, you are going to own that, even if you've been hired to do that, and you actually need to assign and transfer the copyright over to your client for them to own that. So if you're designing a logo for a client, or any of those examples, writing something from your client, designing anything, you need to have language in your contract that is assigning and transferring the copyright from you to them, and then they become the copyright owner. And so that's important for many reasons. First, I think most clients reasonably expect to own the copyright, to the designs or to the work that they commission. It's just that not a lot of people realize that it's not automatic. And secondly, they need to be empowered to enforce those rights. So if someone is committing copyright infringement against this work, so someone, steals it from their website and republishes it, steals their logo or whatnot, they need to own the rights to that to be able to do something about it, to be able to stop that infringer.
Yeah, that's super interesting. And you're right. Something I don't think I think about, and I'd imagine other people aren't, of like who owns this after it's made. That's super interesting. And that kind of leads me to, this is a weird question, but I think other people are probably wondering this too. So many websites, we all put in the footer, the little C icon with the circle around it, and then typically the business name in the bottom. Is that like, because you're talking about the common, what did you say, common use?
Common law.
Common law,
yeah.
That we just all like have the copyright to the work. Is that what people are trying to say when they put the C with their business name, or have they done an extra step to do that?
So it depends. That notice that you're talking about that most people have at the bottom of their website, it's not required by law. So you're still going to have common law rights to anything that you create, even if you haven't put that there.
Okay.
However, by putting that there, you're putting people on notice that you do own the copyrights to it. And so it's really more of a notice element. And the reason that's important is because if someone does infringe on your designs or your copy or whatever it is, it's going to be part of your cease and desist letter, or part of your case against them, to say, we had this notice, you were put on notice. It's not required, because even if I were to take a Post-it note right now and write a poem and then put it over on my nightstand, technically I have copyright over that, whether there's a notice or not. But it just bolsters your position to have that, to make sure that you're putting people on notice of that. But if they infringe on your designs, even if you didn't have that, it's still copyright infringement.
And that's so helpful to know, because that's what I thought, was that it was like automatic in that sense too. But I know the whole time I've had my business, I've had that at the bottom of my website, but I haven't done anything special to have that. So that's why I was wondering. I've had people ask like, hey, what did you do to be able to like say copyright in the bottom? So that's helpful, that it's like, yeah, it can be a reminder that we own what's here.
Yeah.
And let's actually, with that, talking about the why of why we want the little C in the footer of our website, copying in the online space is such a big problem, especially with things like Pinterest. And I know, gosh, from my own experience, I've had clients' logos sold on Etsy, like saying, hey, this person logos, I have people listing them who did not make it, saying, hey, I'll make you this logo. I've had testimonials stolen and my name changed. I've had my privacy policy copy and pasted and stolen, all kinds of things like that. And so I guess my question for you is, I know that's a common thing of people saying, hey, that blog post someone else has is like almost the same as mine, or hey, they like basically copied my website layout or the words or whatever it is. When that happens to us, like, what should our first step be, in your opinion? I can also share like my thoughts on it from what I've done. But like, what's the first step? Like, is it legal action or talking to the person? Or like, what do you think?
Yeah, definitely not legal action, because that's not, it may lead to that if it's worthwhile, but that's not really efficient for you financially as well initially. So the first step is generally sending a cease and desist letter. So a cease and desist letter is just basically a threat letter, and it can be worded very nicely. It can be worded sternly, or it can be worded very friendly. And it just means, hey, knock it off. This belongs to me. And essentially, the teeth behind the cease and desist letter is the threat of a lawsuit down the line. So generally, the first step is you are being amicable, and usually it might include language like, we hope to resolve this amicably, and you're asking them to remove the content. remove the content, or, it depends on what type of content it was. If it's something that's been printed off, then usually you're asking them to destroy any copies. If it's just digital, then you're asking them to take it down and to not use it again. So a cease and desist letter. And usually if people comply with that, then that's where it ends. Mm-hmm. Now on the internet, sometimes it can be difficult to get a response in those situations. So you have another backup option. I think that's probably the first step. And then your second step can be to send a DMCA takedown notice to the website host. So that's where you're contacting the host of their website and you're saying, this content is copyright infringement. I own the rights to this copyright. You can actually go online and you can see the elements that you need to include in a DMCA takedown notice if you're going to send that to a website host. So that would be the second. Then the third, it's kind of like you have a pot of boiling water and you start out at a simmer, and if that doesn't work, you're like cranking up the heat. And so then if usually a DMCA notice would at least be effective in taking the content down, because the website host is legally obligated to do that.
To clarify real quick so people know what you mean, when you say the host, what do you mean by that specifically?
So for example, like one of my websites is on Wix. So you'd be contacting Wix with a DMCA takedown notice. I have another website on Showit. So you're contacting Showit, sending them a DMCA takedown notice. If it's content that's on social media, so it's on Facebook or it's on Instagram, then you can file a report with Facebook or Instagram. Mm-hmm. Saying that this content is committing copyright infringement against your legal rights. So that's generally the course it would take. And then if you had damages for some reason, like if them using your content cost you money in some way, like so on Etsy, for example, if they were actually making money off of your designs or something like that, then that might be a situation where you want to collect compensation from them, and it could lead to a lawsuit if you weren't effective in just dealing with the party directly. Now, within that, you need to think about whether it's worth it to you or not. So it can take a lot of, energy and time and stress to deal with that. If you're going to be hiring a lawyer, which is the most effective way to actually solve the problem and collect compensation, then you need to think about the legal fees. And so are the legal fees that you'd potentially be paying worth the loss that you've even incurred? Is it worth it to you just in terms of the stress of the situation? And thinking of all of that, you also want to consider, is this really a threat to your business overall? So if it's one person who has, stolen some blog articles from you or something like that, it might be very annoying, but you want to think about whether it's really harming your business long term. It really might be in certain situations. If someone is, completely ripping off your brand, in multiple ways, and they're gaining traction, then you have both copyright considerations and you have trademark considerations potentially too, if they're, using your business name or using your logo. And so you definitely want to protect the long-term health of your business, even if something is a stressful situation, but really weigh all of those factors carefully and talk to an attorney about all of that, because they can, help you think of the pros and cons of responding to it. And a good attorney should not encourage you to rush into legal action. A good attorney should tell you when something is not worth your time.
Yeah, that's super helpful. And like a thought on all of it, I mean, I think the reason copying so hard is because it is, like you said at one point, emotional for you as the creator. And I've never taken legal action against anyone, and I hope I would never have to, but most of the time when you email someone, like you're saying, the cease and desist letter, I'm always just as nice as possible, and people almost immediately take it down because they typically know they did something wrong. Right. And they're like, oh, they're typically, I've had people be extremely apologetic where it's like, I'm almost like apologizing to them for bringing it up because they were like so nice about it. Because I think people sometimes just don't realize they're taking inspiration at too far, or sometimes people
Yes.
do blatantly copy and just get caught and are mad about it. But with you, what you were saying about emailing the host with that Etsy problem, I ended up having to contact Etsy, and they made the person, or I guess they took it off on behalf of me. And that
Yeah.
was super easy. And they had, like you were saying with Facebook and Instagram, they had a form that I filled out, and it was simple.
Yep.
Yeah. Okay. And that's so helpful, thinking about the starting with just reaching out, later a lawyer if needed. Okay. I love that. And I mean, I guess last big question on contracts with team members and contractors. Like, what is the thought on all of that and how to do that well?
Yeah, so that's just like your client relationships, that's a relationship, and it's really important to have a contract from the very beginning. My advice would be the same. So when you are hiring a new team member, an independent contractor, a freelancer, you want to have an agreement in place. Now, typically, a lot of freelancers are going to have their own contract that they provide to you, and that's fine. But also consider, everything can be a negotiation. So just because someone provides you with a contract doesn't mean it has to be on a take it or leave it basis. You can read through that or have a lawyer read through it, and suggest changes if there are parts of it that you don't like. That should be a two-way street. If you have someone, let's say you're hiring a new VA and they don't have a contract, you absolutely want to provide one to them. And for the same reasons. I mean, you want to make sure that obviously that the work is done. And like I mentioned, it should be balanced. So on the other side of things, having a balanced contract when you're dealing with an independent contractor, to include clauses that are beneficial for them, might look like, if I delay, like if you need to get my approval on something and I delay the process, then we're agreeing that you can have a day for day extension. So if I'm delaying things or if I'm causing trouble to the project, it's, you're not held to the same timeline or things like that. That makes the agreement more equitable. And then, certainly all the same clauses, limitation of liability. And like I said, if you're providing the agreement to a contractor, it's going to be slightly biased in your direction. That's normal, like the governing law and things like that, but it still should be fair and balanced.
Okay, awesome. That's super helpful. I guess, is there anything else you can think of where you're like, this is something people should know about contracts that we've missed? I know there's a lot out there, but anything you can think of?
So one thing is, some people say is, are emails binding? So like, let's say you didn't have a contract and you were just emailing back and forth, or maybe you do have a contract and you are so you're adding new responsibilities, maybe for yourself or maybe for your freelancer, and you're making those agreements through email. Is that binding? So it depends, but the answer is generally yes. But it's best practices to have an addendum to your existing contract. So that's an addendum is just kind of an additional document that should say that this is incorporated into the original agreement. So even though it's a separate piece of paper, you're executing it separately. You're not signing a totally new contract. The first agreement still is in force, but this is a legal document that you're signing that becomes part of the original contract. And that is a much better approach than just relying on emails for many reasons. But if you did have an agreement by email and you're wondering if that's enforceable, it depends on the situation. A lot of times those agreements might be, or they probably are. Sometimes contracts need to be in a signed writing to be enforceable, but usually, if you're providing services like design services, or maybe you're making a logo or something like that, and you're just changing the timeline maybe of your deliverables or something like that, then the language probably will be enforceable,
Mm-hmm.
but you do want to get it in an addendum ideally.
Okay. Yeah, I hadn't even thought about that with emails. That's so smart. And one more thing I'd love to add just for people to remember about contracts is that we should understand our own contracts is like a good thing to always remember. Like a client should be able to say, hey, can you like explain what you mean here? And we actually are able to say like, yes, this is how I meant for that to mean. So I think that's important too.
Yeah, absolutely. Very important. And all of the Contractista templates come with a video tutorial.
Oh, that's
I'm not sure if anyone really watches the whole 40-minute thing, but there are nearly 40 minutes, and I walk you through every single clause, explaining what it means. And so even if you don't want to tune in for the full 40 minutes, if a question pops up, so you get an email from a client like, oh, what does this mean? Then you can just refer to the video and watch that and give them that explanation.
Yeah, that's perfect. And you're the one for the graphic design one you have is the base I use for my graphic design template too, just for reference to everyone. Yeah. So that's helpful too with the video to make sure we all understand what we're saying. Cause even just, I mean, I hired someone to do some copywriting for me last month. And there was something, I actually read her contract and there was something in it where I was like, wait, what does she mean by this? And it was really nice because I was able to email her. I copy and pasted the piece of the contract and said, hey, can you explain this more? And then she like explained it perfectly. And it was like, yes, she actually did know what she meant by that. And it was a little like confusing to me reading it because it felt like a lot of legal language, but I feel like that kind of reminded me of how important it is that we're able to like interface with people about it.
That's great. And that made her seem so much more professional
Yes.
to you than if she obviously had just copied and pasted this from somewhere and thought, I don't know, it sounded good.
Yeah, hey, I'll take it out. That's fine. Sorry.
right.
Yeah. Yes. Okay. Well, this has been amazing. I hope everyone listening feels more empowered to know all things contracts. So incredible. Thank you so much for being on the show. This was awesome.
Oh, thank you for having me, Elizabeth.
Thank you for listening to the podcast this week, friend. I appreciate you being here. And hey, if you enjoyed this episode, I want to tell you about something. I would encourage you to check out my website template shop. Over on elizabethmccravey.com, you'll find Show It website templates, and they are easy to use, strategically designed, and created to help you book more clients and customers. Maybe your current website is really boring. I don't know. Maybe it is, and maybe you don't want to hurt its feelings, but you know it's true. And your website needs to be strategically and intentionally designed in order for it to convert your viewers into raving customers. And that's what these website templates do on MShop. These are pre-made website templates built for the Show It platform where you can plug and play your content into the template with ease and then get started with a website that is made to actually make you money. Isn't that what we all want, right? So go shop the templates at elizabethmccravey.com/shop. That link is also in the show notes. And don't forget that you can actually subscribe to this podcast wherever you're listening so that you never miss an episode. And I would so appreciate it if you left a rating and review for the show on Apple Podcasts, or even just share it with a friend. It's a great way to support the show and then give us your feedback. So thanks so much for listening.